Hey guys, and welcome to the weekly Docket. In Idaho, let's look at the case of Brian Kohberger, who is accused of the murder of 4 college students. Several recent developments have occurred, including some that have generated a fresh round of, oh my God, shaking my head moments on social media. We'll get to those. First, the state bulks up. 2 attorneys are being added to the prosecution team. Defense has also been allowed to bulk up. This isn't surprising due to the enormity of the case and the potential for the state seeking the death penalty. Second, the Idaho Supreme Court tells media you don't have to go home, but you do have to go. The court dismissed the media's petition regarding the gag order in the case. Deep state conspiracy or reasonable ruling? I hate to tamp down the adrenaline, but the order was straightforward. The court said, look, this is your first intervention in this case, and you don't start at the Supreme Court, you start at the trial level. The court basically said, take your concerns to the trial court, and if that court does not give you what you want, and changing the order or rewriting it or whatever, then appeal here. That's fair, and that's normal. The court did signal it understood some of the concerns in the wording of the order, but of course there was no signal that there couldn't be a gag order. I don't think the media has filed the trial court level motion, which it could quickly do since it's basically written all of it in its appeal. Just change the heading, some adjectives, shorten it up a bit, and let it fly. I do think media could and should be able to get an amendment to the order to address the alleged lack of clarity some are hiding behind, but will they bother now? We'll see. So now it's time to look at the oh my God moments. The defense is, or was, as we will see, attempting to subpoena one of the house survivors to appear at the preliminary hearing. This is a process because the survivor is in Nevada and the Idaho court needs a Nevada court to order the attendance. Remember, courts have limited jurisdiction. Anyway, the Idaho court made a certificate to justify the Nevada court issuing a subpoena under its law, and that court did. The survivor's attorney moved to fight the subpoena, and this leads to 2 oh my gods and head-shaking points. First, why would she not want to testify? Some even think this could lead to him being let go, LOL. This concern represents zero understanding of what the proceeding is and no attempt to think about how the survivor might feel about all this. The second is the defense investigator says she has testimony that is exculpatory to the survivor. Now this led to the greatest oh my God, shaking my head moment because social media loves a conspiracy and thinking that without putting any effort into understanding the law, the proceedings, or the facts, they're able to see through the nonsense and know that they are hiding something. All right, first point first, why would she not want to testify? This is a preliminary hearing, people, not a trial. The state simply needs to establish probable cause. They must not have felt the survivor is necessary for that, so the state has not asked her to testify. And if you don't think they have enough to get by the probable cause speed bump based only on what was disclosed in the probable cause affidavit for arrest, remember, this is nowhere near close to beyond a reasonable doubt, then you just don't think. So she probably does not want to travel to Idaho and sit around waiting to be called as a witness for anybody. Who would want to do that? It's highly likely she has a mental state that the guy who murdered her friends is either Kohberger or she just doesn't know who it is. In either case, why would she want to travel to another state and wait around based on a request by defense when she either thinks that guy is guilty or perhaps based on her personal observations, she can't say either way. One thing for sure, again, she is not necessary at all for the state to make its probable cause case. Now, while her attorney, the survivor's attorney, made several arguments in the motion to quash, the one that had immediate and solid merit is that the subpoena was issued against her without a hearing, and the Nevada statute says there should be a hearing. So the court should either quash the subpoena and let Kohberger file a request again and have the hearing in Nevada, or at least schedule the hearing. If a hearing did occur, though, I think the other arguments the survivor's attorney makes would probably fail and she'd be ordered to attend. At any rate, this is now all moot, including the aspersions against the survivor's character for not wanting to appear in the preliminary hearing for what is likely at most a red herring. She and Kohberger's team have agreed she will attend an interview by defense counsel in Reno, Nevada. Based on that, Kohberger's team stipulate to the withdrawal and quashing of the subpoena. Okay, so they're fine with it. That's an extremely reasonable solution, as parties may use hearsay in a preliminary hearing. So in the highly, highly unlikely event she says something that actually helps Kohberger versus just, I didn't get a good look at the person or whatever, they will be able to present it. And that gets us to the second point. Oh my God, she has exculpatory testimony. Right. The defense investigator affidavit reveals in this ultra high quality document where the survivor's name is repeatedly misspelled, spelled in different ways from paragraph to paragraph with zero consistency, that it, quote, became known to him that the survivor has, quote, portions of information that, quote, is exculpatory to defendant. Notice he even misspells Kohberger's name when mentioning this exculpatory conclusion. Fantastic attention to detail. For conspiracy theorists and DNA deniers, there it is in black and white. Even with all the misspellings, the case is a farce. Right. As the survivor's attorney says, the defense affidavit statement is conclusory. Yes, it's just a statement. Oh, I think she's got something that helps him. And it gives no support, detail, or information about the nature in any way of anything that is alleged to be exculpatory. Now, whatever she has to say, she has to say. It seems reasonable to think the best she can do for the defense is give a very uncertain and limited description of what happened at the house at the relevant time and who did it. Even if something she says, he was shorter than Kohberger or taller or the eyebrows were different, that could be potentially helpful, but that does not stop the case at the preliminary hearing phase, which is only about probable cause. And unless they found nothing helpful in all the searches and the DNA is wrong and all the phone evidence is wrong, she's really not in fact material at this phase. Later in the case, sure, a lot more matters at trial because that's the presentation of evidence to the jury for the crime elements beyond a reasonable doubt. Having said all that, making herself available for a defense interview and the defense agreeing to that in lieu of forcing her to come to this preliminary hearing, that's a responsible, reasonable solution by both sides. And so it's likely to disappoint conspiracy-seeking social media trolls. Final note, this preliminary hearing would not take place at all if Kohberger were indicted by a grand jury, because that would involve only the prosecution talking. So some have said, well, maybe the state will still seek a grand jury indictment so that would moot this upcoming preliminary hearing and get past all that. Do you really think the state's afraid of this hearing for probable cause? If they are, they shouldn't be moving this case forward to trial. So while I get that point, I tend to doubt it. I think they will move forward with the preliminary hearing as scheduled. They're not going to lose. And maybe seeing a solid wall of evidence against him will cause Kohberger to start hoping for a plea to life sentence rather than face the prospect of Idaho's death penalty, which is still unlikely to happen, but it does face the new exciting prospect of a potential future firing squad. We'll see. Let's get back down to Florida and check out the Charlie Adelson case. Have you been watching the Adelson case? This involves the murder of Dan Markell, who was a lawyer in Florida, married to lawyer Wendy Adelson. When their relationship deteriorated to the point of divorce, Wendy wanted to head to South Florida with the kids, and Dan did not agree. To say things were contentious is a great understatement. And here's where it gets a little Netflixy. Allegedly, Wendy's dentist brother Charlie stepped in to help solve the problem, perhaps borrowing from the Christian tradition the often overlooked promise of "to death do we part," and viewing that as a solution rather than a commitment. He even joked to his sister he'd get her a TV for a divorce present because it was cheaper than a hitman. So he allegedly confers with an employee and sometimes romantic interest, Catherine Magabana, about coming up with a plan to take Dan out of the picture. Catherine reaches not very deep into her Rolodex to the father of her two children, Sigfrido. Sigfrido and his friend Louis, in exchange for money, allegedly, head north and meet Dan Markell in his driveway and shoot him and kill him while he's in his garage. They then escape in a Toyota Prius, a very sensible green choice for hitmen having to travel long distances for their work. So far, Louis has pled guilty, and Sigfrido was convicted of being the trigger man, and Catherine was convicted on a second trial after the first was a hung jury. So they're all paying the price for what they've done, but nobody from the family yet. Now, Charlie Adelson is the only other person currently charged for this crime, and he's cooling it in jail. He wanted bond, cash bond, but he's being held without any possible bond after the appropriate hearings. Money's not getting him out before trial, to the disappointment of class warriors. His trial is now set for October. It appears his old girlfriend and employee will be testifying for the state. Anyway, I'd listened to a podcast about this a while back, and it's just an insane set of facts as police try to solve it. I haven't touched any of those here, but it's an extremely interesting case, even, of course, though it is sad. One thing that's not a small question is who else in the Adelson family knew about this? Anybody? And what did they know? Did Wendy know? She says no. If you know about this case and are looking for details or get interested via podcast or whatever, and you want to know more details, I recommend the YouTube channel called AA Legal Focus. This channel is run by an attorney in the same county I'm in here in North Carolina. She has a great understanding of the problems of legal domestic disputes and how to try to solve them and just how bad things can get if that does not happen. On this case in particular, she has videos on every aspect of the case, including other attorneys, family members, including Dan's mother, writers, you name it. It's the most detailed examination of this case possible. So let's head to Wisconsin and check in on a follow-up point on Darrell Brooks. An interesting point was raised in the comments on the last video about this scumbag. And I do know that while I have an outstanding offer to him of 1 cent for exclusive rights to his story, and the use of the word scumbag might cause a hiccup in negotiations, I'm willing to take that chance. Anyway, the comment was about Wisconsin doing something to change its bail system to provide greater flexibility to consider public safety. Pretty much everyone was outraged that Brooks was let out on such low bail, including me, but one needs to understand that the judge was supposed to set cash bail only considering future flight risk. Now, they missed the ball on that too, but basically bail was to ensure future attendance. Safety through pretrial detention was supposed to be through a different complicated procedure. Now the Constitution for Wisconsin has been changed to deal with that. Going forward, public safety can be considered in setting cash bail. For those interested further, we'll look at the changes and the pluses and minuses in a video coming out tomorrow. Well, that's it for this week. Thanks. Bye.